The latest news, national issues, the political scene, and conversations with prominent personalities. All these firsthand at the forefront. Good morning. I am Attorney Karen Jimeno. Yesterday, Congresswoman Gertrude Luistro and EJK Victims Legal Counsel Cristina Conti shared their views on the significance of the Quadcom hearing of former President Rodrigo Duterte as key resource person. Today, we will present the other side of the coin and answer the question of many. How far can congressional inquiries go without overstepping the mandate of the judiciary? Live at the BNC studio, lawyer and political commentator, Attorney Ferdinand Topacio. Good morning, Attorney Ferdy.
Yes, good morning, Karen. It's always a pleasure to be here.
Thank you for joining our discussion this morning. And Attorney Ferdy, you've been part of Quadcom hearings as legal counsel. For one with Cassandra Ong during the Quadcom hearing where she also appeared as a resource person.
Yes, I am.
How would you describe the recent investigations or hearings being conducted by Congress?
Well, I would say that not just the recent hearings, but the hearings as a whole from the beginning have been a sort of a roving commission on the part of the House, that four committees of the House, when it comes to legislative inquiries. They have clearly overstepped the bounds of reason, and they have engaged in sheer oppression in so many instances. And this is in contravention of the injunction of our Supreme Court in at least three cases. The case of Ermita, the case of, the recent case of Lincoln Ong, you're very familiar with that. And of course, the case of Neri, which categorically stated that legislative inquiries are not investigative proceedings. They cannot take the place of the police, the prosecution, or the courts.
Would you remember, Attorney Ferdy, as to when this whole manner of conducting hearings started? Because it is part of the Constitution that Congress, Senate, they can conduct inquiries in aid of legislation. But in terms of the manner by which it is being conducted now, where it's taken on similar to a role of, as you said, a roving investigation, which the Supreme Court has ruled on in the past as being unconstitutional. But when did this all start?
I think this was premeditated, if I may say so. For one, this is, as far as I know, unprecedented. Four committees of the House investigating a wide range of subjects from POGO to extrajudicial killings. I mean, it's a stretch to see the connection amongst all of the things that they are investigating. But clearly, there is intention, a deliberate intent to target certain political personalities for liquidation, namely, definitely a former President Duterte, which was very evident during the the last session of the Quadcom.
Well, you mentioned earlier that this has turned into some sort of a roving commission, and the manner in which they conduct the hearings has overstepped the bounds of the mandate of the Congress. Let's look at instances during the Quadcom hearing where some members or representatives acted like prosecutors. Let's watch this first clip.
Ang concept niyo talaga patayin agad ang mga kriminal o yung mga addict o yung mga pusher. Pero ang tanong ko nga, hindi niyo ginawa yan sa mga drug lords. Okay? Hindi kayo nang huli ng mga manufacturer ng drugs. Pero yung mga maliliit, ganyan ang tingin ninyo, ano? Yung mga kriminal na sinasabi ninyo. Ganyan niya tratuhin.
Ganon ako gagago?
Excuse me,
Mo,
point of order.
Ako
Point of order, Mr. Chair. Kanina sinabihan na natin na may rule na bawal gumamit ng manaswang salita or hindi magandang salita.
I'm using a word, gano, am I that stupid?
Well, as you can see here, it seems that, well, this particular representative and some during their questioning were trying to make former President Duterte admit to certain acts that they were alleging or illegal. But is this frame of questioning proper for a House hearing?
Well, definitely not. Because legislative inquiries cannot take the place, or are they intended to supplant investigations either by the police or the NBI or a pronouncement of guilt or innocence by the court. What the legislature should secure from witnesses or resource persons appearing in these legislative hearings are information, data, in order for them to intelligently formulate pieces of legislation. As in fact, the last hearing was totally unnecessary because the group of Congressman Dan Fernandez has already filed a proposed bill with respect to EJ case. Well, no matter what we think of the superfluity of that bill, there is already legislation formulated. So why are they still continuing with hearings on the EJK?
Mm-hmm. And Congressman Rog Gutierrez asked former President Duterte to confirm bits and pieces of Colonel Roina Garma's statement when he was not furnished a copy of the affidavit. Let's watch this clip.
Read the affidavit so that I would not be in a position to correctly really to respond to your question. I am at a loss kasi ikaw yung may hawak ng... So you are now trying to investigate me. Para kang investigador. Yung may hawak ka ng affidavit dyan, executed by another person, and you're trying to confront me with the statements made in that affidavit, and you're trying to exact an answer from me. Pagka ganon, maghinto tayo dito. That is not proper.
Mr.
That
President.
is not fair.
Well, former President Duterte is a lawyer and also formerly a prosecutor. Is he correct in saying that it's not fair to be asked to confirm statements from an affidavit that he has not seen?
Well, I could not have said it any better than the former president. It is not fair not only during legislative inquiries, but in any proceedings because of the principle of due process. I believe that Congressman Rodriguez, is that Rodriguez or Gutierrez?
Gutierrez.
Gutierrez is also a lawyer. But therein lies the difference between, well, we are seasoned veterans, trial veterans, Karen. Our life is appearing before the court. And that is the difference between people who litigate for a living and lawyers who have not seen the inside of a courtroom, like perhaps Congressman Gutierrez, because there are nuances in proceedings that you cannot acquire by just studying law and reading law books. So, kaya nga nasopla siya tuloy ni President Duterte.
But since this is a congressional inquiry, is that allowed in the rules?
Nonetheless, because it doesn't matter. Of course, in legislative inquiries, the rules of evidence are relaxed. The rules of evidence only apply in a suppletory capacity. But nonetheless, in the Constitution, it is stated very clearly that all the rights in the Constitution must be accorded to a resource person. And that includes the right to remain silent, the right to be protected from incriminatory questions, the right to due process, and the right to be presumed innocent. And these are the very rights that are being violated by our lawmakers, the very same people who, in their oaths of office, swore to uphold the Constitution and all the laws of the Philippines.
And let's talk about substance. So Congresswoman Jinky Beatrix Luistro stated that former President Duterte was guilty of conspiracy by inducing others to commit crime. Let's watch this clip.
Challenging anybody or everybody who makes the accusation whether it is really true or not, it may be true, file the case in court because may korte tayo. And even if I will admit na totoo yan, you have to go to court because I will make the admission there again.
So when a member of Congress in a hearing in aid of legislation accuses a person of being guilty of a crime, is that within the bounds of their function?
Definitely not. You know, Karen, Luis Cho is that kind of person that, she's a lawyer also, as we all know. But, Luis Cho is that kind of person that if you're not very smart, you will think that she's smart. But if you're smart, you know that she's not. Because even in her questioning regarding the supposed extrajudicial admission of President Duterte, not only in pronouncing the guilt of Mr. Duterte in legislative proceedings, but when she says that the admissions made in a legislative proceeding by the former president amount to an extrajudicial confession.
Yes,
She is wrong because, of course, some of the elements are there. Voluntariness, sound mind, the awareness of the consequences of the admission. But there is one essential factor missing that all we trial lawyers know. That is that the extrajudicial confession, to be effective, must be made within the context of custodial investigation. And we were taught in first-year law that a custodial investigation starts when a general inquiry regarding the commission of a crime starts to focus on a particular person. A legislative hearing cannot be custodial investigation because the parameters are limited in a legislative inquiry. As the Supreme Court said, and I again repeat, for the edification of our congressmen, of our members of the House, the legislature is not a court, it is not a police agency, it is not a prosecution office, it does not investigate the commission of a crime. The sole purpose of a legislative inquiry and hearing in aid of legislation is to ferret out facts and information and not to determine the guilt or innocence of anyone, nor even the existence of a crime or the commission thereof. That is not the place of the House of Representatives nor of the Senate.
Well, I guess a lot of people will say, paano kung guilty talaga yung person that is appearing before Congress or Senate? What would be the proper procedure when you do have someone, for example, appearing and that person is guilty of certain offenses?
Well, for one, people should again be reminded of the constitutional injunction of the presumption of innocence. Number two, as President Duterte so very aptly said during the hearings, file it in court. Kaya nga may korte tayo. We have a court to determine the guilt or innocence of a person with respect to the commission of a crime. We have a legislature that makes the laws. We have an executive that executes and implements the law. That is the genius of a tripartite system of government that we have under the Constitution. And anything that the legislature does that impinges on the prerogatives of the judiciary dilutes that separation of powers.
Mm-hmm. And when you go to courts, for example, at least you have a judge that's trained with the rules of court and how to conduct a real trial, whereas if you're in Congress, you have people that are not lawyers and do not have that same experience as judges. And
well, as Dan Fernandez said, hindi daw naman kailangan maging abogado. Pwede daw namang i-Google.
Talaga. Okay. Well, Congresswoman Arlene Brosas also forced, in some instances, the former president to respond to her question only by yes or no. Let's watch this clip.
Responsable kayo kasi polisiya nyo yon. Kumbaga, tatak Duterte. Dahil polisiya nyo rin yan, tama ba? Sa Davao, nung nasa Davao pa kayo. Tama ba na tawagin po itong Davao model or Davao style, Mr. Chair?
I cannot control the semantics.
Mr. Chair, yes or no? Davao style.
Do not ask me to answer yes or no. You are not an investigator.
Mr. Chair, tayo po ay nasa investigasyon kasalukuyan,
Yes,
Mr.
but you
Chair.
are not an investigator. Why are you asking me to answer
Mr.
yes
Chair,
or no?
tinatanong
So your comment on that, is that part of the rules of the House where you can force a resource person to answer yes or no?
Of course
Only.
not. Of course not. First, again, we have to look at the Constitution on how to conduct these legislative matters. The Constitution says that resource persons are supposed to be treated with respect and dignity and their rights respected. You do not browbeat or bully or bamboozle a resource person. That is against the Constitution. And some of these people, including Representative Broas, appear to be laboring under the misimpression that a legislative investigation is an investigation in strictissimi juris, meaning in the strictest sense of the word. No, it is not. It is just called an investigation, but actually, it is an investigation in aid of legislation. They seem to have forgotten that qualification in the Constitution. In aid of legislation, there is no meaningful aid to any legislation by bullying a witness or extracting certain things that are not germane to any pending litigation. What is the pending litigation that they are contemplating? In fact, under Ermita, they even have to furnish the resource person with a copy of the proposed legislation, which they are not observing in this case. At least insofar as my client is concerned, we have not seen any proposed legislation because those attachments to a subpoena are supposed to limit the extent of the inquiry. This safeguard is not being followed in the Quadcom's proceedings.
And right now, since you have said that it seems that this Congress has overstepped its bounds when it comes to the role to conduct investigations or hearings in aid of legislation, what do you think can be done legally to address concerns that Congress is overstepping its mandate when it comes to congressional probes? But before you answer that question, let's take a short break. At the Forefront, we'll be right back. Welcome back at the Forefront. Attorney Ferdy, there are some who say that Congress is overstepping its mandate in conducting these hearings that are supposedly in aid of legislation. Should that be the case, what can be legally done to ensure that there's no overstepping of their functions?
Under the present circumstances, of course, the recourse would be to the judiciary. Because under our Constitution, we have expanded the powers of the judiciary to include processes or remedies wherein the court may step in whenever there is grave abuse of discretion on the part of any branch or instrumentality of the government. That includes, of course, the executive and the judiciary as a check on the excesses in the exercise of the powers of these departments. But, of course, Karen, you and I know that a judicial recourse is a slow avenue. And we cannot blame the Supreme Court, especially if the case is filed before the Supreme Court, because we only have 15 justices who are occupied with a lot of other important cases. But then, of course, under the tripartite setup of our Constitution, that is the only plausible recourse. Because these people in the House right now seem to think that the concept of separation of powers is that they do not have to listen to the mandate, to the injunctions of the Supreme Court. That is wrong because our civil code says that pronouncements of the Supreme Court become part of the law of the land. The same laws that these people in the House have sworn to uphold and protect when they took their oath of office. But of course, we all know the motivation. people know the motivation, and if these people think that they're scoring points with the masses, with the Filipino people in abusing their powers, especially that of contempt, you can see how they have abused that particular power, then they are dead wrong. Because if you look at the commentaries during the live feed of the last hearing, of the Quadcom hearing, you will see that the overwhelming number of responses, of comments, are lopsided in favor of the former president. So they're not, kung nagpapapogi sila, well, they have to find another way. I am sorry.
Well, one of the significant moments during the Quadcom hearing that almost led to an altercation was when former Senator Sonny Trillanes presented bank accounts, alleged bank accounts, and some members of the House of Representatives were forcing the former president to sign a waiver. So, one, is it legal for Senator Trillanes to be presenting bank accounts there? Where was he able to get copies of the bank accounts? Because normally that's something that you would require a court proceeding and a court order.
Yes, definitely. That is why I'm saying that the Quadcom hearings have degenerated into an inquisition and as a court of star chamber, wherein the purpose is no longer to secure information that will lead to good legislation, but to embarrass and target certain political personalities, even at the expense of breaking laws like what Trillanes did. You know, in a court of law, that would never have been allowed. That person would have been charged with a criminal offense or even cited in contempt.
In relation to what?
For trifling with the law, for presenting evidence that is clearly illegal, which it would appear that the Quadcom tolerates or even encourages. And that is the danger of this Quadcom. It normalizes the illegal and weaponizes the legislature.
And there were instances where former President Duterte did say that he takes full responsibility for the drug war campaign under his administration. Do you think that, one, this leads to an admission of guilt, or some of the members of the House of Representatives keep saying, are you willing to put that in writing and to sign that? So they are implying that it's an admission of guilt of some sorts.
Well,
what is really the value of that, and how do we distinguish taking full responsibility for a policy or campaign that you undertake and versus accountability under criminal law?
Actually, by demanding that it be put in writing and under oath, they are again betraying their ignorance. Because all of the proceedings in the Quadcom are already being transcribed. You can get transcripts, and they're already under oath. So what is the point of requiring the former president to put that in writing and under oath? All of those things are already done. And by saying that it takes full responsibility, the president has exhibited exemplary leadership qualities. It's like a former president in the United States who has a sign on his desk that says, "The buck stops here." Meaning to say that all responsibilities shall be attributed to me because these policies are mine, they were set by me, and they are mine alone. That is in stark contrast to leadership that says, anong gagawin natin? So you can see the contrast between the present leadership and the previous administration in terms of strength and integrity when it comes to the implementation of policies.
So where do you see this going from here? Do you think that Congress will file cases, or will they ask the DOJ to file cases against former President Duterte?
The only action that Congress may take with respect to the conclusion of legislative investigations is to file a report, present it to the committee, have it approved by the plenary. But with respect to filing criminal or administrative cases. The most they can do is include in the report that a copy of this report should be furnished the appropriate agencies for their own action. So that, in that sense, it is useless to try to seek guilt or innocence here or the commission of a crime because in the end, after all is said and done, a lot has been said, but nothing can be done by the legislature. So, inutil po when it comes to investigating the commission of a crime. That is better left to agencies with more investigative competence and training.
So, former President Duterte was making that point that if they want to file cases, it should go to the DOJ and then the courts.
Yes, the courts are open. In fact, in the case of Kian de los Santos or de los Reyes, the person who was a collateral damage in the war on drugs, the policemen who were responsible for his death have undergone trial. They have been pronounced guilty and they are now serving sentence. So our courts are open, our courts are working. So what the heck are these people doing determining guilt or innocence in legislative proceedings? They're just wasting the people's time and the people's money. And they are exposing themselves as buffoons at the same time.
Well, former President Duterte also said that he welcomes the immediate probe of the International Criminal Court or ICC on his war on drugs. This was President Bongbong Marcos's statement yesterday.
If yun ang gugustuhin ni PRRD, hindi naman kami haharang doon sa mga ICC. Hindi lang kami tutulong. Ngunit kung pumapayag siya na makipag-usap siya o magpa-imbestiga siya sa ICC, nasa kanya yun. Wala na kaming desisyon yun.
President Bongbong Marcos said, hindi kami haharang, hindi rin kami tutulong dun sa ICC. What does that mean? Is he saying that the Philippines will still not rejoin the ICC as a member?
I believe in fairness to the incumbent president, Ferdinand Marcos. I think he's being consistent in his policy of the Philippines having withdrawn from the Rome Statute. It will not extend any material assistance to the ICC. But of course, he is also correct in saying that if it is the subject of an ICC investigation, if it is the choice of that person subjected to an ICC investigation to present himself, of course, that is his own prerogative and the government cannot stop that.
Attorney Chrissy Conti was here yesterday and she believes that the ICC still has jurisdiction to try this case despite the Philippines' withdrawal from the ICC. But should that happen, if there's an investigation here and then Congress recommends the filing of cases against President Duterte, does that negate the basis for ICC's investigation that there is no proper judicial system working in the Philippines in terms of trying extrajudicial killings or crimes against humanity?
Yes, that is the point exactly. Actually, it doesn't matter what Atty. Conti believes. What stands is the foreign policy, the official foreign policy of our government with respect to that as enunciated by the president. And, you know, there is a good reason why some countries are not signatories to the Rome Statute, such as the United States, because having an international criminal court come to your country and investigate your citizens is a big slap on the face of your government. It is a huge derogation of sovereignty. It's like saying that we cannot handle our own internal affairs. Someone from outside should step in. And that is why so many countries did not sign the Rome Statute. I do not know if this is a flaw in our race or in our national psyche, that we seem to delight in people interfering in our internal affairs. I do not know what is wrong with these people. That is why probably we are stuck in the Middle Ages insofar as political development is concerned.
But should former President Duterte submit to the jurisdiction of the ICC, how would this go? What legal resources would be available to him? Should he be represented by Philippine counsel or would he have to find foreign counsel to represent him in the ICC?
I think there is no dearth of people, of legal luminaries here in this country who are qualified to represent litigants before the ICC. Someone who immediately comes to mind is Attorney Harry Roque. So, well, of course, it is his choice whether or not to avail of counsel here from the Philippines, or there are other counsels who specialize in that sort of litigation abroad. But that will be entirely his choice. But I know that he is a smart person. He knows his rights. He's a lawyer. He's a former president, so he should have the smarts to make the best choice when it comes to his legal defense.
And what's going to happen should the ICC find the former president guilty? Can they issue a warrant of arrest, or can they also put him in jail? That's really the question of a lot of ordinary people that are watching how this is unfolding.
Well, of course, just like what they did to Milosevic, they can have him arrested. But it all depends on
Do they have that power? Do they have their own police that can go into a country to conduct an arrest?
Well, they cannot. They will still have to depend on the municipal law enforcement authorities of a particular state. Just like what happened to President Vladimir Putin of Russia. There is an arrest warrant out for him, but of course, Russia, he being the head of state of Russia and the head of government, probably, will not implement any arrest order. And all of those states that he has visited, they will also not implement any arrest order against him because they are his allies. And therefore, they will not mobilize their law enforcement agencies in order to effect such an arrest. So it's all dependent. If the president is in the Philippines, there is an arrest order, then it will be the judgment call of the executive as to whether or not to implement that warrant of arrest, whether it is through the ICC, through the Interpol. It doesn't matter whether there are treaty obligations, actually. It is always the choice of the executive to implement or not to execute any particular arrest order, based not only on treaty obligations, but in the best interests of the country. Because if you try to arrest a former president who has implemented during his tenure a very popular program, the war against drugs, you injure the national psyche so much that the country may take a long time to recover, and you erode executive prerogative and executive action of presidents in the future. So all of these things have to be taken into consideration. Hindi lang we have a treaty, we belong to the Interpol group of nations, etc., etc. That is why we need a president who has wisdom, more than legal knowledge, that in this case, our president is not a lawyer, more than the advice of his people who may be parochial in nature.
Okay. And do you think that the current administration is cautious in pursuing a case against former President Duterte for fear of backlash in the 2025 elections? But before you answer that question, let's take a short break. At the Forefront, we'll be right back. Welcome back at the Forefront. Attorney Ferdy, in your opinion, do you think the current administration is cautious in filing cases against former President Duterte for fear of backlash in the upcoming 2025 elections?
Actually, before cases can be filed, there has to be a complainant. Because as I've said, while President Duterte has been making these statements, even under oath, before the Quadcom, that pinatay ko, I killed people, etc., etc., the element of specificity is lacking there. In that admission, in that supposed admission, who are these people that he supposedly killed? Where were they killed? So as to attach jurisdiction, because as we lawyers know, venue is jurisdictional in criminal cases. It has to be filed where the crime was committed. So these are the obstacles that have to be hurdled before any cases can be filed. I do not think they are cautious in filing cases. so much so that they are refraining from filing cases. But I think it's just a matter of lacking this sufficient basis for initiating criminal prosecution against the former president. Because it all has to start with the complainant. And the complainant has to state the elements of a crime in a sworn statement and a complaint affidavit. So it all starts from there. Or investigative agencies such as the NBI or the police should investigate and then ascertain facts which may lead to a finding of probable cause for the filing of cases. So I think that is the legal obstacle.
Yes. So you are answering this as a lawyer,
Yes.
meaning you're saying that there are no concrete evidence, or you even lack a complainant to file the complaint, so that is a big barrier to filing the cases. But from a political standpoint, assuming they are able to gather witnesses or complainants, do you think that politically there is some hesitation because of a backlash?
Well, I cannot say that right now because there are as yet no cases, not even case development, as they would call it in investigative parlance. And I would like, again, to disabuse the minds of our people that the statements made by President Duterte before the Quadcom are not admissible. They are useless insofar as filing a case before the proper prosecution office is concerned.
Well, former President Duterte is a lawyer, and sometimes I also wonder, why does he make confusing statements like that? Why would he say that I killed this person or I killed some people? But then when he is asked to clarify, he does not really give any definite statement that he committed certain crimes. So why even make controversial statements like that?
Because I believe that he is a student of Sun Tzu, the art of war. He's trying to confuse his enemies. He's trying to make actions wherein he's being unpredictable, so that his enemies do not know what the next step will be, and they do not know how to counter his moves. And he has always been very good at that. Remember, before he ran for president, he filed his certificate of candidacy, and then he did not show up on the last day. He had another person file the certificate, and then just at the last minute, he substituted himself for that person. And the strategy worked, because from out of nowhere, he became president when he was not given much of a chance at the start of the campaign.
Well, I think he's succeeding in that, because even as a lawyer, I get confused watching the Quadcom. But I'll pick your brain as a lawyer. So again, what started even this Quadcom, what started it is really supposedly a hearing in aid of legislation, which is what the Congress is supposed to do if they were to exercise their powers under the Constitution. But if they were to come up with a law in relation to EJ case, or taking off from the experience of former President Duterte, because it seems like a lot of people in the House of Representatives kept insisting that he was guilty by being a principal by inducement because of things he would say during his press conferences, like patay na yung mga criminals. If that had to be translated to legislation, I remember Congressman Dan Fernandez used to be a guest here at the forefront, and he did say, naisip niya raw dapat may law na pagka may mga pronouncements na ganon and you're head of state, dapat may criminal liability. But for those that are listening here, for example, kung magkaroon nga ng ganong klaseng batas, would that have any effect on actions that have already been done by former President Duterte in saying those statements?
First of all, we all know that laws, especially penal laws, are prospective in application unless they are favorable to the accused.
Meaning prospective, it applies to the future, hindi pwedeng retroactive.
Yes, hindi pwedeng pabalik. Ano? Number two, si Attorney Google, si Dan Fernandez, is of course, again, incorrect in saying that such pronouncements should be made the subject of criminal liability. There is a principle of executive prerogative. He should read the cases regarding President Nixon, wherein presidents, in the exercise of their sovereign functions as chief executive, it cannot be sued for anything that happens in the exercise of thereof during their office. Otherwise, if you do that, then you will be tying the hands of the president in executing policies, because instead of doing what is best for the country at the time, he will be thinking of possible criminal liability in the future. You will make the president inutile.
Well, we do have an immunity from suit for the president
during
or an
the term,
incumbent president.
yes.
But what if you have this law that would make a former president liable for statements made in the past?
That is not advisable, to be charitable about it. And then, with respect to EJK, I'm sorry to say that after having read the proposed bill, it does not say anything new. For instance, they define EJK, but extrajudicial killing, etc., etc. But every killing is extrajudicial unless there is a death penalty and the courts impose the death penalty. If I kill Dan Fernandez now, that would be extrajudicial killing in the loose sense of the word. And then they say that if in the event of an EJK, the penalty should be the maximum, a reclusion perpetua. That is already covered by the revised penal code. For instance,
for murders, right?
Yeah, murder. For instance, they say there is a reward system. But a homicide is qualified to murder if it is done in consideration of a price, reward, or promise. A murder is aggravated, a killing is aggravated by the fact that it is committed by a public official. So it's useless. Nothing in that proposed bill says anything new. So it's like the old saying that the mountain labored and brought forth a mouse.
That's a very deep analogy. But for those listening here, what is the definition of extrajudicial killing? Especially since you made a statement a while ago that all types of killing is extrajudicial unless it is ordered by a court. So what is extrajudicial killing?
They say that it is killing committed under government policy, etc. But that is already covered. As I was saying...
What law covers that currently?
Well, the revised penal code, there is homicide, there is murder. Murder is aggravated, a killing is aggravated to murder by certain conditions, which, as I've said, includes price, reward, or promise. A public official, although he's not the one doing the killing, the actual killing, may be indicted for murder if he's a principal by inducement. So, it is already there. The laws are already there. I think they made the proposed bill just to be able to say to the people, look, we came out with something. In the words of the Gen Zers, mema. May masabi lang.
Ngayon ko lang naintindihan what that means. I never knew what mema meant.
May masabi lang.
Okay. So, after all of this, what then is the output that we can expect from all of these inquiries, the Quadcom hearings, inquiries in aid of legislation? Kami as a public, as taxpayers, what output can we expect?
Well, your guess is as good as mine, but if it is just that proposed EJK bill, I'm telling the Quadcom right now, this is so lame, gentlemen and ladies. If there is a law against Pogo, of course, I welcome that actually. I've always been anti-Pogo. I welcome that. Of course, there is already an executive order by the president prohibiting Pogo, giving it only until the end of the year. But of course, that has to be codified into law to give it a sense of permanency. With respect to EJKs, I don't know, you know, they even put in the proposed bill the creation of a commission for victims of EJKs. That is adding another layer to the bureaucracy because the courts are sufficiently competent to award damages to the families of victims of murder or parricide or any other kind of killing.
Well, here, Attorney Ferdy, we've seen that the hearings can take such a long time, inaabot ng until midnight for the Quadcom hearing. But some of the questions are repetitive. So do you think that there would be some value to not allowing television coverage of the Quadcom hearings so that some representatives of Congress will not be incentivized to try to get airtime.
Well, I wish, but they will not allow that, of course, because they're using this platform not in aid of legislation, but in aid of re-election, and as a platform to demonize their political opponents. So hindi po sila papayag. I mean, these people, Dan Fernandez, Benny Abante, si Jinky Luistro, Jinky Luistro, all of these people were political non-entities before the Quadcom hearing started. Now, everyone knows them. But I'm telling them there is a difference between being nationally known and being nationally derided. And I think they are the latter.
Okay, and since you mentioned earlier that you would welcome legislation related to POGOs, do you know the status now of those investigations? Will the Quadcom still have hearings in the future, yung related kala Alice Guo, Cassandra Ong? Are they still looking for Wesley Go?
Well, insofar as the Senate is concerned, the many members of the committee investigating that have evinced the intention of terminating the meeting soon, the hearings. I do not know about the Quadcom because these people seem to be milking the investigations for all they're worth for whatever motives they may have, because some of these people doing the heavy lifting like Paduano, Mr. Contempt himself, seem to be on their last terms. So I don't know what their motive is, but I do not see any end in sight. Probably after the hearings wherein the former president was summoned by the Quadcom, there will be an end in sight for all these hearings, because I think it is becoming a matter of fatigue, of hearing fatigue, so to speak, on behalf of the people. When the people are smart, there is no longer a monopoly of information. Small, not small, but those outside of the mainstream, like Billionario.com, we have so many other platforms, are a very good conduits of information for people to be forming their own conclusions. And I think the majority of the people have already formed their conclusion that these things are going nowhere and there is starting to be some fatigue.
Well, yesterday, Paulo Duterte was interviewed after the Quadcom hearing, and he said that, that was the other day, sorry. And he said that, tanungin niyo kung magkano ang natatanggap per session. What does that mean? Is this based on a fee per committee hearing, or what is he implying?
I really don't know. I have no information. I have no information to form an opinion. I would like to be fair and think and give our lawmakers the benefit of the doubt that they are doing this for things other than pecuniary considerations. But then I could be wrong, of course.
Okay. But thank you, Attorney Ferdy. We appreciate your insights today.
Thank you so much, and it's always good to be here, kay Compañera Karen.
Thank you so much. Sayang kulang na tayo sa time.
It's okay.
In the absence of a formal mechanism to ensure that congressional inquiries remain consistent as being in aid of legislation, it is up to the discernment of the House of Representatives to toe the line between being a legislator and a court prosecutor. Be timely informed, be insightful of the news, always stay at the forefront. Join us again on Monday for meaningful conversations that would help you form an objective personal opinion. This is Attorney Karen Jimeno. Thank you for spending your hour with us. Nakakatawa.